Sam Sherman, one of the best attorneys in San Diego. Thank you for joining the podcast.
Thanks for having me, sir. I appreciate it. It's good to be here.
Absolutely. So, Sam, tell the viewers what you do and what geography do you cover?
Sure. So I'm an employment lawyer, which means I represent companies. I'm on the company side, and I really help companies with really two aspects of their dealings with employees. So I do a lot of advice work, which is really just me trying to help them get ahead of issues, address issues before they happen, answer questions for them to try to avoid risk. So that could be employment offer packages, separation packages, how to navigate complaints or investigations, wage and hour compliance, any of those types of things. And then in addition to that, I also help them in the litigation side around those same areas. So a lot of wage and hour right now, meal break issues, rest breaks, overtime, things like that. And then in addition to that, the stereotypical kind of harassment, discrimination type things. The primary focus of the practice is really San Diego. The vast bulk of our practice is in San Diego, but we also have clients in Imperial County, Calexico, Orange County, Riverside, and LA. So post-COVID, the geography's expanded a bit.
So primarily Southern California.
For sure.
Wonderful. And you represent the management side. So I just want to be clear. You don't represent employees.
Exactly.
You represent owners of businesses.
Exactly. There's plenty of good lawyers out there that represent the employees. I do not do that work. I exclusively represent the employers.
Got it. So I recently bought a business and
congratulations.
Thank you so much. And so now I've been thrust into this world of wage and hour.
Yeah.
Can you explain what that is to a person, for example, who maybe just bought a business like I did, and now they have all these rules and regulations that they have to follow? And how do they do that? How do they mitigate it when they don't do that?
Yep.
Give us that information.
It's really tricky. It's like I tell everyone, anyone can have a kid. No one tells you how to be a good parent. Anyone can buy a business. No one tells you how to comply with the law. And it's real easy to mess up. The labor code's that thick. The Fair Employment and Housing Act, really complex. There's a lot of ways to mess things up. And so, the best advice I always give to people is, depending upon your size, have that team in place. The biggest mistake I see small businesses make is they think, well, this person's really smart. I'm going to put them in charge of HR. This person's a really good bookkeeper, so they can do HR. That's the biggest mistake you can make. There's really good outsourced resources out there. If you get big enough, hire someone that really knows this stuff, and then truly, have legal a phone call away. Yeah, you're not going to want your lawyer for every run-of-the-mill issue. You're not going to want your lawyer to be your HR person, but you want your lawyer to be there for the stickier things, the thornier things, so that you're calling that lawyer on the front end and not on the back end. As far as the wage and hour stuff, it's the number one thing we see messed up, and it's very unforgiving.
Wow.
So there can be things that you do that is done at the employee's request. The employee wants to take their meal break late. Well, under the law, it has to be taken at a certain time period. And if it's not, it doesn't matter if the employee requests it or not. You have to give it timely, overtime. It has to be paid out. So some employers will do things like saying, well, I'm going to let someone work 9 hours on Tuesday and only 7 hours on Wednesday, and then it all comes out as a wash and we're fine. And the employee was fine with it, so there's no liability. That's not true. The laws are very strict about overtime, about compensation. So all those wage and hour components are really tricky. There's lots of rules around, again, meal breaks, how they have to be provided, how they have to be taken. Rest breaks, same thing. The timing of them, the duration of them, where you can go or not have the employees go on those breaks. Overtime is a big one that we see a lot of, particularly around if you have hourly employees with a commission. What's the right rate for overtime? We see that messed up all the time. So usually an ounce of prevention early on can really get you set up in a good spot.
Got it. So you mentioned consent, that a lot of employees will say, hey, I'm okay with that. So how does that come back around to bite the employer if at the moment the employee was totally fine with what was done?
Yeah, it's the number one thing I get in the cases that I receive is my clients will have that initial meeting with me and they'll say, Sam, this doesn't make any sense. The employee wanted me to do it this way. The employee asked me to do it this way, and now they're suing me over it. It's insane. And literally that's what happened. I had a client one time came to me about 4 years ago, and he had a bunch of his employees that were designated as independent contractors, and they should have been employees. I met with him. And I said, look, you have exposure here. These people should all be employees. They're not independent contractors. They're only doing work for you. They're working full time for you. They're doing exactly what your business does. These are employees. Okay, Sam, I'm going to change them all.
Mm-hmm.
I don't hear from him for like 4 years.
Wow.
And all of a sudden he calls me. Sam, I'm getting sued. Who's suing you? This guy that I can, this guy that we talked about 3-4 years ago. What's he suing you for? Oh, for misclassification. He should have been an employee and not an independent contractor. So wait a second, we met, you changed it. He goes, no, I never changed it with him because I went to him. I asked him, or I told him we need to change him to employee status. He said, no, you're not changing me. If you change me, I'll quit. I want to be an independent contractor. So I kept him that way. I didn't tell you about it, Sam. And now 4 years later, this guy's suing me for misclassification that he should have been an employee. And this is the craziness that I deal with all day long for my clients.
So he didn't tell you?
Nope.
And he just got back into his business, head down, plow forward, and then boom, it just came back to bite him.
Yeah.
Wow.
Yeah. And it's one of the things I always tell clients is, look, I'm going to give you my best advice.
Mm-hmm.
Sometimes it's maybe not exactly how you want to do it, but that's okay. At least be honest with me, tell me. And then there's maybe still some things we can do to mitigate risk if you don't take the advice. The number one thing that he messed up on is not taking the advice, not telling me about it, and then 4 years later having a big problem on his hands.
Yeah. Can you explain for the viewers, those who should be employees and those who can be independent contractors according to the law?
Yeah. So the law changed on this a few years ago, and it was one of those funny areas where before the law changed, there was a lot of ambiguity. And there was this other test that had a lot of gray areas to it, and employers would call me and they get so upset. Sam, why is this test so vague? Why is there so many gray areas? I wish we had some clarity. Mm-hmm. And then the law changed and we got more clarity. And then clients called me and said, darn it, Sam, why is there so much clarity? I hate this new test. And so now what California has is it's called the ABC test. Mm-hmm. It's a 3-part test. It focuses on whether or not this worker has an independently established business that truly is out there marketing itself out and holding itself out as a separate business. It has separate clients. It's trying to get separate clients. Another function is who controls the work. Is the worker control when the work is done, how the work is done, et cetera. And the big prong and the hardest prong is the second element, which is whether or not the worker is performing services along your same business lines. Mm. And the problem for employers is they have the burden of meeting the test, and they have to meet all 3 elements. And it doesn't matter how strong you are in a couple of the elements. If you lose the third, you're done. Mm-hmm. And so that element of whether or not the worker's performing work outside of the employer's normal business is the hardest one. And the best example I give people is, my IT person, contractor. I'm not an IT company. Mm-hmm. My bookkeeper, contractor. I'm not a bookkeeping company. But if I have someone that's providing legal services to my clients, that's where it gets tricky. And so that's usually where I tell clients to start is this person performing work that's exactly what you're doing for your clients?
And what if they're doing that for 10 different law firms just like yours?
That can be okay. They're still an employee, and they're just a part-time employee. They should be paid part-time for the hours they work for you.
Got it. So they should still be an employee.
100%. Yeah.
Got it. Okay. Let's go back to wage and hour. So I'm going to paint a picture here for you. You have an employer who knows you, has an outsourced HR department, and they are very focused on following the law. They have managers who are there day to day. So the owner isn't there day to day necessarily, but the managers are. And they've been briefed and informed how to follow these rules. But in audits, they're continually breaking these rules. How should that owner deal with that so that they're not sued later?
Well, it depends on what rule is being broken. I mean, usually with any of these things, if the employer messes something up, there are penalties. There's things that have to be paid. So for instance, if there's no meal break given, there's a penalty for that. If the overtime isn't done correctly, you can go back and fix it. So if you're seeing that there are issues, you need to go in, you need to fix it, you need to make it right by the employee. And then you really need to do some training for that manager of why does this keep happening? We've told you what the processes are supposed to be. Mm-hmm. We've told you what you're supposed to be doing. Why is that not happening? Where is this breaking down? And so usually that's what we recommend is having that conversation with the managers about what's expected of them. And then you can take a carrot or stick approach. Is this something where you have to discipline the managers for not following, or is this something that we should incentivize compliance so that we're getting that compliance in order?
And what's a worst case scenario if compliance isn't gotten control of?
Well, your worst case scenario is a lawsuit. And your worst case scenario from that is either a class action lawsuit or a big, PAGA lawsuit where someone comes in and sues you claiming that all these rules were messed up and they were messed up for a group of employees. And that can get very expensive. So it's gotten to the point where you don't want to put your head in the sand if these things are happening. You want to get out in front of it.
Got it. And you mentioned PAGA. Could you just define what that is?
Yeah. So a PAGA lawsuit is what's called a Private Attorney General Act lawsuit. It's a really popular claim right now where a lawyer tries to sue on behalf of a group of employees, particularly for wage and hour violations. So you could have one employee that's disgruntled, goes to a lawyer's office, and then all of a sudden sues, claiming that a group of these employees didn't get their meal breaks, didn't get their rest breaks, didn't get overtime. It's a very big, expensive, cumbersome case.
Got it. And there are timelines associated with that employers need to know about?
Yeah, there's a lot of important timelines. The first is that the law was changed last year. And so some of those changes are very pro-employer, but it requires us to act quickly. So the very first one is that the employee, to start that claim, has to send a letter to the state of California. When you get that letter, you have 60 days to do an audit of what's going on, what went wrong, and cure it. And so you have to call employment counsel immediately when you get that letter and make sure they're on it. They're doing that audit, they're doing that cure, and they're putting these steps in place to fix these issues.
Got it. This is a question I have because I don't know. I don't live in your world. Are these lawsuits brought primarily because an employee or former employee went to a lawyer? Or are there lawyers out there somehow? This is the way my mind works.
Yeah.
Are there lawyers out there who know when someone's no longer employed and they're just dialing, or they pay someone to dial the phone book to see if someone's disgruntled? So are these initiated primarily by employees, or are they initiated primarily by attorneys who are seeking out employees?
I think stereotypically what happens is someone gets fired, they're unhappy, they go to a lawyer and they say, hey, I got let go, I'm upset about this, this wasn't fair. They never counseled me, this was harassment, someone was rude. And the employer looks at it and says, look, that's not a valid claim. But let's look at your time records, let's look at your pay records. And they find some little issue and they turn a termination that was lawful into a PAGA case. And that's stereotypically what we see happen.
Got it. Interesting. So let's talk about demand letters, or what you like to call nasty grams.
You've heard me make that comment before.
Yes. So again, you're an employer. You're trying to do everything the way you should do it, and then you get a demand letter. Explain what a demand letter is, and depending on the requests made or the demands and the veracity of that letter, how an employer should approach it.
Yeah, great question. So the first thing we normally see a plaintiff or a former employee give is you get a letter from a plaintiff's lawyer asking for that employee's personnel file and pay records. That's the number one thing we see most often. And that's usually when you can figure out that you have a little bit of a problem on your hand, is when someone's asking for something like that. What I tell clients to do is, as soon as that happens, that's when you call counsel. Sometimes clients think, well, I can just get on the documents, no big deal. What we tell clients is immediately call your lawyer, have that lawyer write to the plaintiff's lawyer, say I represent the company, communicate through me, and then have the client send the lawyer all the documents. We can go through it, we can make sure we have everything, we can make sure there's nothing included that shouldn't be included, and give that to the plaintiff's lawyer. There are timelines with those productions. So there's deadlines for the personnel file and for the time and pay records. Usually once we get that done, I would say stereotypically within about 30 days, maybe 45, you're going to get that demand letter from the plaintiff's lawyer. That's when if you haven't gotten a lawyer involved at that point, that's when you 100% have to. And particularly what we see right now is a lot of letters from plaintiffs' firms up in Los Angeles.
Okay.
Used to be they never came down here to San Diego. They didn't like San Diego. Now we see it all the time. And so a lot of those firms don't even file lawsuits. They just send letters all day long. And they're smart enough to ask for not an absurd amount of money, and you're thinking I can negotiate that with them and get a good result. We have a particular way we handle these firms, and usually it results in them going away. So you want to get that lawyer involved super quickly as soon as you get that demand letter. If not, when you get that request for personnel file and pay records.
So do you ever have employers who receive those, they call you, and they tell on themselves to you, hey, Sam, we received this, and yeah, you know what? It's probably true. Do you get those from time to time?
It is extraordinarily rare.
Okay.
It's insanely rare. I mean, and it's pretty ironic because as business owners, you would think, oh, a business owner, they'll still take it, they'll step up, they'll take responsibility if they mess something up. I have maybe seen it, a handful of times in my entire career. Usually the employer is very emotional, very upset about it. How do we feel as employers? We feel like we work really hard. We have a lot of stress. We give people jobs. We try to do well for them. No employer thinks they're trying to take advantage of their workers.
Yeah.
And so they really take it personally when these claims are filed. And I think that's the number one thing that the employees and former employees don't realize is that when you make these allegations against your company, it can cause a lot of bad blood and hurt feelings because usually, we think we're doing the best we can for our people.
Yeah. So you mentioned that most of the time when people receive these, well, maybe I shouldn't say most of the time, but there are times when employers receive these demand letters that they're not necessarily from the best law firms with the best intentions. It sounds like they're looking for a payday for themselves and for the employee, but maybe there haven't been really any egregious violations of the law. Now, with that said, how often, if you can give us a percentage, if you can't, but just generally speaking, how often are those demand letters received by employers and they do turn into litigation and even where the employee wins?
Yeah. I would say that, I'll tell you what I tell clients, which is that if every time they got a demand letter, the plaintiff sued, I'd be a very rich man and I'd probably have twice the book of business I do.
Got it.
Depending upon what's going on, there's very often we request that we take a very aggressive position early and see what happens. Now there's times, let's say on a wage and hour case where there's just, you messed up. The overtime rate is just 100% wrong. There's no two ways around it. Something very black and white. The employees were, not taking meal breaks at all. There's no way around it. In those situations, I think you got to take it a little bit more seriously and try to be, proactive and reduce the exposure. But a lot of times in response to these demand letters, we recommend a pretty aggressive stance and see if they'll actually file a lawsuit. As far as what frequency they actually win, the adage is that 97, 98% of cases resolve before trial. I think that's true. I think the biggest thing that the plaintiff's bar is leveraging right now and that is causing a lot of settlements is that there have been some very large jury verdicts. If you lose as the employer, you owe attorney's fees to the other side. We've seen judges award some very high numbers in attorney's fees. And so there's, some risk for the employer for sure.
Wow. So there's some additional risk even above what the demand is for the violations, paying the other's attorneys.
It's the tail that wags the dog.
Wow.
100%. You can have a case that is a $50,000 or $100,000 case, and if you don't resolve it early, a year and a half from now at mediation, the other side could be asking for $500,000 because of all the fees they've incurred, and we see that happen all the time.
Got it. Does it go the other way around? So if you go to trial and the owners or the business actually receive a positive verdict, that the plaintiff has to pay their attorney fees, or it doesn't go that way?
It does not go that way. There are ways to get your fees recovered, but it's extraordinarily difficult. The burden is very high. For the plaintiff to get their fees, all they have to do is show that they won, and it could be any dollar amount. For the defense to win, they have to show that the claim was frivolous, that the claimant knew that it was frivolous at the time it was filed. It's a very high burden and very tough to win. And then even if you win it, you got to hope that this employee or former employee would have the money to pay it back, which is difficult. So it's a very challenging thing for employers.
Do employees have any risk at all other than their time when they accuse their former employer of these violations?
It's the time. It's, money. You want to hope that plaintiff lawyer is a business person, is thinking about it like a business person. Is this a case that they want to spend their time and their money on and their resources on or not? And it's just like in any case, I'll tell clients that normally when a client comes in the door, they're upset, they want to fight. They tell me, Sam, I'd rather pay you than them. I don't want to pay them a penny. And I always tell clients, you're feeling like that now, but wait 6 months. Wait until you keep getting phone calls and emails from me asking for documents, asking for information. Wait until you start getting calls from me about your deposition. Wait until you've received 3 or 4 invoices that you have to pay. At some point, you're probably going to get to the point where you think, Sam, let's at least discuss if we can get this thing done. And on the opposite side, time does heal all wounds. So usually once you fire that employee, they're upset and they want blood. When you make them work for 6 months, a year, 18 months, at some point they get to the point where they say, look, do I want to really go to trial? Do I want to spend a week or 10 days of my life sitting there? Do I want to take the risk that I do all this and we don't get anything?
Yeah.
And so, they have those same thoughts. And we do see that over time, on the plaintiff side, their appetite for litigation also wanes.
Can you talk to us about the environment here in California, juries, judges? You did mention a little bit, there have been some, huge windfalls for employees where employers had to pay a lot of money. If someone is going to trial, what should they be concerned about?
Well, I think you want to make sure you have a lawyer that's tried a lot of cases and that knows what they're doing. I think you want to, on these employment law cases, there's certain settlement offers that you can make early on that can put you in a little bit more aggressive position on those attorney's fees that we talked about. And you really want to make sure for trial that you understand the risk. I mean, as the employer, the biggest thing you got to understand is, what is that risk at trial? How much am I going to have to pay my attorney to go through trial? What's my risk on damages if I lose? And what's my risk on attorney's fees to the other side if I lose? And you counter that with what you can settle for. And that's really, all these decisions are business decisions.
Yep.
And it's just like what I was talking about before. Our client will say, well, I'd rather pay you than them. Well, that may be true, but if I can get the case done for 10 or 15 grand, you tell me you wouldn't pay that and have this out of your hair? Well, yeah, I do that, right? That's the answer I get all the time.
Yeah.
On the flip side, I tell clients, well, look, a client will come to me and say, Sam, I don't want this stress. I want to settle. Just get the case done. And I'll say, okay, that's fine. But if they're at $500,000, you're going to pay $500,000, or do you want to spend 20 with me to save you 200, right? If in any other situation I'd told you, Ryan, give me 20 grand and I'll give you 200 back, you say absolutely, right? But the paramount thing is making sure you're being smart with your money. I think the paramount thing with trial is making sure that you're really analyzing the risk and the finances. Because I'll tell you that in my experience, even clients that go to trial and win, they're rarely ecstatic at the end of it.
Yeah.
It's taken years. It's taken years off their life. It's been very stressful. And they're as frustrated after trial as the first day they got that lawsuit filed.
Wow. If the plaintiff wins and there is a judgment, how does the employer, how does the owner have to make those payments? What's the payment structure post litigation?
Well, it's the risk of that trial. Is if you lose, you get a judgment. Once that plaintiff's lawyer has a judgment, he or she can go after, accounts receivable. They can go after your, it's going to attach your bank accounts. It can do all those kinds of things to try to enforce it. So sometimes it is the benefit of settlement, is then you can negotiate those terms. You want to take 6 months or 12 months to pay it back.
Got it.
Do you want to take 60 days to pay it back? You have some options if you settle. But if you go to trial and you lose, interest starts running, and the plaintiff lawyer has a judgment, they can start enforcing, and that can be scary.
Wow. So interest starts accruing the day that the judgment is enforced?
Exactly. 10% per year.
10% per year.
Yeah.
So that's just devastating to a business.
It could be crippling.
And I'm sure that there are scenarios where businesses have gone out of business because they've lost one of these lawsuits.
I'm sure. Fortunately, I've never had that situation happen, which I'm very proud of. I've never had someone have to go out of business for any case, and every client's worried about that. My small business clients are always worried about that, and it's the stress of those cases. For a small business, one of these cases can be a bet the case or a bet the company kind of case.
Yeah.
And so you got to be thoughtful about that.
Yeah. What I love about your practice is that, again, you have the advice side and then you have the litigation side, and you do a lot in the community to prepare business owners to make the right decisions day to day on behalf of their employees. And what I call that is building the wall before anyone storms the castle. And so what I'd like you to do next is talk to those employers about how they can react to situations inside the business. So, for example, any type of leave, if you can explain the different types of leaves, perhaps when employees come to you with a hardship, right? And they're saying, hey, I need a few days, or maybe I need a month.
Yeah.
How responsive does the business owner have to be to those scenarios when, as a business owner, you're saying, well, hey, I have a business to run. you might not be here, but I've got 300 people coming in the door. Or, you're part of this staff and now I've got to adjust here tomorrow. And guess what? I don't have enough time to adjust.
Yeah.
So when employers are faced with these different scenarios and circumstances, how are they supposed to adjust? And then obviously there are some, one in particular, you got about 9 months to deal with that.
Yeah.
So explain those different leave options that people have and then how employers should react to those.
Yeah. So the reason that leaves are important is there's probably one of the top 5 ways I see employers getting sued.
Got it.
And depending upon the size of your business, there can be various leaves you have to give or don't have to give. And so that should all be spelled out in your handbook. You should have a good handbook that is specific to the size of your company. And depending upon that size, you may have to give a particular type of leave or not. The most common things that we see from the litigation standpoint are 2 types of leave: medical leave and pregnancy leave. And the reality is, employers should do a few things in response to those issues. First is, again, if you're not sure if you can give the leave, call your lawyer. Don't call him or her on the back end, call early. The second one is how this stereotypically happens, particularly around medical leaves, stress leaves, things like that, is you'll be about to fire this person. They'll know they're about to get fired.
Oh, no.
And all of a sudden, they'll put in the leave request. And the call I always get from the client is, Sam, I was about to fire this person. Then they requested leave. I want to fire him now. I say, don't do that. Sit tight. Let's wait. Let's see if they even come back, because they're typically waiting for us to screw this up. I think 9 times out of 10, they're already speaking to a plaintiff's lawyer, and that person is helping them navigate this in the hopes that we mess it up, and then they pounce. And what I've seen in my practice is when you handle those leave requests correctly, oftentimes what we see is the employee never comes back because they see we haven't messed it up and they don't want to be there. We don't want them there and they want to move on. And there's plenty of jobs out there right now to have. So just keep in mind that depending upon your size, depending upon how long the employee's been there may be certain rights they have under the California Family Rights Act, under the Family Medical Leave Act, under pregnancy leave laws, things like that. And so you want to be thoughtful about whether or not you can accommodate those leaves or not. And you want to remember that the other thing I see clients wanting to do all the time is kind of mess around with the employees on their return. Right? So they think, well, as long as I'm not firing this person, I'm not going to get sued, but I can make their life miserable until they just quit. And you can't do that either. And the case law is very strong on that. So, there's been cases where, changing job titles, changing duties, changing reporting structures, all these things can be the support of a discrimination claim or a retaliation claim. So you really want to make sure that you're putting them back into that same position that they were in before the leave. And if you're not, you want to be speaking with your lawyer to find out why and what your risk is.
Got it. Yeah, I mean, if someone's on the way out, it's just common sense, right? That if you make them mad and they're angry at you on the way out or they think they've been done wrong, we live in California. Everybody knows this is a litigious state. So of course they're going to go somewhere and see if they can get money just to spite that person who made their life miserable. So I'm glad that you identified that, brought that to the surface. And now what I'd like to do is shift to something you mentioned yesterday when we talked, immigration. Obviously, that's a hot topic.
Yeah.
You're receiving a lot of phone calls at the headquarters of Sherman. So talk to us about that.
Yeah, it's a big hot button issue right now. We have a lot of clients in the restaurant space. We have a lot of clients in the janitorial space. We have a lot of clients in the landscaping space. All these industries with stereotypical high percentages of immigrant workforces and potentially undocumented workforces. We're not personally doing the immigration compliance piece with them, but we're seeing them being a lot more proactive on doing audits, on ensuring the documentation that they have is all correct, making sure their I-9s are all dialed in. So I would 100% recommend that right now. If you're any employer, I would do an audit of personnel files right now.
Got it.
Making sure your I-9, you have I-9s for everyone. Making sure you have the documentation for the I-9, whether it's a passport or the ID or whatnot. And you want to make sure you have those documents in place so that if the immigration office does come knocking, you have everything dialed in. And then I do recommend, again, it's not me, but if you are worried about having a high percentage of your workforce potentially being undocumented and being subject to some sort of audit by ICE, I would be calling immigration counsel right now to see what options do you have in place so that if this happens, you don't have 50% of your workforce decimated one day and no way to navigate that or handle that. So we're seeing a lot of issues with that right now, a lot of concern in the community, business community.
What are the risks to employers if they don't have the proper documentation?
Well, if ICE comes in, there are penalties and fines that they can impose if you don't have your I-9s and your compliance side. I think the number one thing that we're seeing right now, though, is not as much concern from the business community about that. The concern is what I kind of mentioned a few minutes ago, which is more a workforce issue.
Got it. Okay.
Is that if ICE comes in and forces us to, get rid of half of our workforce, how do we replace that workforce in a short period of time that doesn't cause massive business disruption? And that's what we're seeing a big concern with right now.
Got it. Wow. This topic is so dynamic. It's always changing. There's new laws. There's new leadership. So it's great to have someone like you to bridge those gaps for your business owners.
Yeah.
I want to shift
it's
now.
Hard too, if I can make one more point, is that, the federal law and the state law in these areas is usually very much opposed to each other.
Wow.
So we see on the federal side a lot more aggression on enforcement, and on the California side, you see a lot of protections around enforcement. So that's why you really got to get employment or immigration counsel involved so that you make sure you're not doing something that you think complies with federal law that then violates California's laws that can tend to be very protective.
Got it. So what we're going to do now is we're going to talk about your role in M&A transactions and what new or prospective business owners who are buying an existing business need to know, and again, how they can leverage you or someone like you, your firm, in the transition. So I'm just going to set this up, Sam. There are ETA professionals out there, entrepreneurship through acquisition. It's exploding as the baby boomer generation is now transferring their businesses to the next generations. We're seeing private equity come down into the SMB space, but then we're also seeing, people who are working 9-to-5 jobs saying, I want to get out of the rat race and buy a business. So with that said, we have very sophisticated buyers, and then we have novice buyers, right? Sure. Whether they're sophisticated or novice, here's something they're going to face. They're going to face a business that they're going to own that has a history. And so there are typically two different types of acquisition strategies. There are the stock sales, and then there are the asset sales. Can you talk a little bit about the difference in those purchase options and how those impact buyers post-close when it comes to how those employees have been treated by the prior ownership?
Sure. Yeah, and I'll do the typical lawyer caveat, which is I'm not a business transaction lawyer. I'm not an M&A lawyer. So all these areas I can't touch on. But with regards to specifically employees, what we see is if you're doing a stock purchase where you're purchasing the assets and the liabilities, you better be doing some due diligence where you know what you're buying, where you know what exposures they have, and you know what's going on, and you see if they need to have some sort of a holdback for that statute of limitations period. So if you have a lawsuit that covers the prior ownership, that there's funds in place that can cover that exposure.
Got it.
So that's number one. If you're doing an asset sale, what we typically see happen is that the selling business will fire all the employees on the date of the transaction, and then your company that's purchasing will rehire everyone on the first day that you own the business. And if you're doing that, well, you need to make sure you're doing that. And then when you do that, you need to make sure that you have someone helping you with, again, making sure you get new personnel files set up for everyone, new W-4s, new I-9s, new benefit enrollments, new everything, new handbooks, to make everything clean going forward with these employees. And I think that's the time you want to take a fresh set of eyes on the practices. Do you have issues with wage and hour compliance? Do you have issues with overtime? Do you have issues with odd pay structures that you got to get your arms around? And so you really want to do that due diligence early on, because instead what we see is you buy a company, you keep doing things the way they've always been done, but they weren't compliant. And now all of a sudden you've walked yourself into some exposure because you haven't, put a fresh set of eyes on things to see what's legal and what's not. Got it.
And the new ownership, let's say they do take over, they do identify that, hey, these employment practices have been sloppy and they start implementing very clean, tight employment practices. Either they get a new handbook, they contact someone like you. Are they still, and let's just talk about the stock purchase, are they still liable for what the prior owners did if, for example, there are employees who transition with the new ownership?
Yeah, so it's going to depend on what the documents say and what your business transaction lawyer drafts up for you. That is the massive risk, though, that if you've done the stock sale, that you do own that liability. And so you want to see what practices you're putting in place to protect yourself from exposure from time period that you didn't even own the company. You weren't even controlling these things. And so that's why some of those set-asides and some of those other things can be helpful. But the big thing that you want to look at when you're identifying those issues is not just fixing it, but what do you want to do on the look back to correct it so that you don't have that exposure, you reduce that exposure. And it could be something that you're doing in due diligence. I'll be honest, I don't see a lot of audits in due diligence that focus on employment law and exposure and things like that.
Yeah.
I've always been surprised by that. I've had business transaction lawyer colleagues tell me, oh, this is the new wave, it's going to start happening. And it doesn't. You know, all people are worried about is what's the purchase price, what's the earn out, what are the payment terms? And you know, really people aren't focusing on that exposure on the employment law side. And I get it. But the exposures have been getting so big, it's at least something to have someone look under the hood of and just make sure there's nothing massive or glaring.
And how often do you see sellers come back and participate in litigation if there are, again, issues that have been going on year after year after year, and then an employee decides to sue after the transfer of ownership?
Yeah, what you're going to see is the plaintiff's lawyer is going to sue everyone they can, right? And we're dealing with that right now with the client where the statute of limitations period covers them and a prior owner. And the plaintiff's lawyer doesn't realize that right now. But once they figure it out, they're going to add the seller.
Got it.
Because all the plaintiff's lawyer cares about is having as many funding sources as possible.
There you go.
And they're going to say, look, I'm suing everyone. You guys figure it out. I don't care who pays what, but you guys figure out who's paying it. And we see that all the time. We see that where companies use PEOs for their employees. We see that where you use contractors to provide temporary workers. The plaintiff's lawyer doesn't care. They're just going to sue as many entities as they can and hope that's additional funding sources to fund the settlement that they want.
Got it. Okay. So as we close out, what I'd like you to do here is just talk to that business owner and just say, hey, look, I've got 2 minutes with you. I've seen it all. Number one, don't do this. And number two, do this. What would you say? Just like, hey, come on, don't do that. But hey, you need to do this. What would those two things be?
I think a couple things on don't do this, right? The number one thing, don't play internet lawyer. Don't play Google lawyer.
How about ChatGPT, Gemini, Grok, whatever it is?
Yes,
what do you think?
I was going to get into that as well. I would not do that. I would not have those devices draft documents for you. I've seen that happen. I had a client recently that got an offer letter from something like that, and the offer letter said they were at will and said they had a 2-year term of employment. Which one is it? Are they at will or they have a 2-year term of employment? So do not do that. I always tell clients, don't turn me into a janitor cleaning up messes. My pet peeve is a client calls me and says, Sam, this is what I got. This is what I did. Did I do this right? Well, how can I help you at that point? At that point, it's too late.
Yeah.
So the number one thing you can do is not see me as a line item on an invoice. See me as a risk mitigation tool.
Yep.
See me as a partner, someone that you're going to call. You're going to spend 5 or 10 minutes on the phone with me so you avoid risk instead of having to pay me tens of thousands of dollars later because you screwed something up. And so I really think, that's where you can be really proactive, really get ahead of things. All of us in our profession have these nails on the chalkboard things that people say about their profession. Mine is when people say, oh, Sam's an employment lawyer. Hopefully I never need to talk to you. If you're a business owner and you let those words come out of your mouth, you're seeing things wrong.
Yep.
You need to see employment counsel as a partner to help you avoid risk that you're talking to. If you have, 30, 40 employees, you should be talking to employment counsel at least a handful of times a year. Again, probably not on big things, but there are going to be things that come up that you just want someone to bounce ideas off of. Can I do this? Can I not do this? Is this compliant or not? those are the clients that don't get big cases. I don't make a lot of money on them, but I love helping them out because they use me the right way.
Yeah. And so what would you say? Do this. Whatever you do, do this.
Call me first. Call me on the front end. I would say right now with some of the PAGA stuff that we've talked about, really take wage and hours seriously. You know, if you have more than 15, 20 employees, you should be having someone come in annually to audit, to look under the hood of the business and see if your practices are correct, to do some training, to do some compliance. It can save you a lot of money in the long run.
Got it. And I just want to tag on along that. And can you explain when an outsourced HR company ends and you begin? So again, someone takes your advice and they're not a huge company, and so they hire an outsourced HR firm. Maybe they do the handbook, maybe they give them some advice on some things. But I heard one lawyer say when I was speaking with them, but they're not an attorney. I think they do a great job, but they're not an attorney. So can you give us that line where an outsourced HR company is no longer going to add the value that you do?
For sure. I think, one, you got to be thinking about, when you need them. When are you big enough? I say there's, any size you should be thinking about it, because, if you don't have an employment law background, even if you only have a couple, 2, 3, 4 employees, you should be looking at outsourcing HR. The things that they can really be helpful with: employee onboarding, employee offboarding, job descriptions, benefits compliance, things like that. They're great at. Employees have questions about their pay stub or things like that. That could be great. Where you want to get employment counsel involved is when things get a little bit thornier. You want to roll out a commission structure to an employee. You need to have that in writing. You have to, by law, have a contract on it. Again, you have a tricky leave situation. You have a tricky termination. You get that nasty gram. The good outsourced HR companies know where the line is and where you should get employment counsel involved.
Got it.
And I think it empowers you as well, because the number one complaint I get from clients is that the problem with outsourced HR companies is they're so darn risk averse. They want to tell you, document everything 14 times before you fire someone. They want to tell you, never do this and never do that, because they're afraid if you get sued over advice they've given you, they're going to get sued.
Got it.
And then when they get you there where it gets to the tough decision, they're going to say, well, just call employment counsel. You're going to be sitting there going, well, I paid you to analyze this issue for the last 2 weeks, and now you're telling me to call counsel. How is that helpful? So that's why I think on the thornier things that we've been talking about, call that employment lawyer. And oftentimes, and what I like to empower my clients to do is be aggressive with, getting promoting the good people and getting rid of the bad people, not letting your employees take advantage of you. So we don't want to be risk-taking, but we try to empower the client to run the business the way they want to run it, without being so afraid of getting sued that they feel like they can never discipline someone, they can never fire someone. Well, sometimes when you're working with a outsourced HR, they're not going to empower you to make those decisions.
Got it. So just to sum up this episode, what I hear you saying, Sam, is if you're a business owner and you don't know, and one of these scenarios comes up, the first thing they should do is call someone like you, or if they know you, call you.
Yeah.
Because here's what I'm hearing from you. Then they will know. There's no more ambiguity. It's clear. Hey, you messed up. You need to do this. Or, you know what? Don't worry about that. Do this or this and you'll be fine. But the worst thing, the most costly thing, is that you don't know.
Yeah.
And then when it rises above the surface, like you said, it could be too late at that point. And then you either have to start doing depositions, go to court, all of that. And that's when it starts to stack up. In California, I think you would agree, or maybe I could just ask you, but it would seem to me that California is most of the time going to favor the employee, that it's always on the burden of the employer to prove that they didn't do what they're being accused of. Is that right?
Oh, 100%. Yeah,
all right.
It is true. And I think, have someone in your corner. There's lots of good employment lawyers. Pick one, have that person as a resource. I think it's invaluable. For
awesome.
Sure.
Well, I really appreciate you joining me, especially on opening day, where my San Diego Padres are going to beat the Atlanta Braves. And have a great rest of the day, Sam. Thanks a lot.
Thanks for having me, buddy. I appreciate it.